Thank you for joining us. My name is Nduoko, and on sign language is Millicent Aranda. Mukurweini MP John Kaguchia has been arraigned at the Milimani law courts a day after his arrest over alleged incitement remarks made during a political rally in Nyeri County. The legislator was arrested on Monday and initially taken to the Directorate of Criminal Investigations headquarters for processing before being transferred to Kamukunji police station, where he spent the night in custody. His arraignment comes amid heightened political tensions, with supporters and opposition leaders questioning the circumstances surrounding his arrest and calling for equal enforcement of the law in cases involving alleged hate speech and incitement. We're going to cross over now to the court live in Milimani to take note of those proceedings.
And the questions that we are putting is whether or not the charge that is before you is sufficient enough to warrant the accused person to respond to the same. I associate myself with the submissions made there earlier on, but only have this to say, Your Honor, that the premises upon which these proceedings are mounted must be supported by the law. And therefore, at the particular time of commencing the proceedings, this court is not restrained from interrogating the conditions precedent. It has been highlighted before, Your Honor, the transgressions that befell our client before, during, and at the time of the arrest. The court is invited, Your Honor, to interrogate whether there was whether there was compliance with the Constitution, not violation of the Constitution, but compliance with the Constitution. I am laying emphasis on compliance and distinguishing it from violation because I know my learned friends will go to the Magistrate Act and pull the magical Section 8. But that's what I'm saying. I am inviting the court to look at the application of the Constitution. And that question, Your Honor, of the application of the Constitution has been dealt with by the Supreme Court in the case of Hussein Khalid versus the ODPP, Supreme Court petition number 21 of 2017 at paragraph 23 and 24. Supreme Court, Hussein Khalid versus the AG, Supreme Court petition number 21 of 2017. At paragraph 23 and 24 of the judgment, the Supreme Court, oh yes, Your Honor. I beg your pardon. May I take it again? Hussein Khalid versus the Attorney General and others of the ODPP, Supreme Court, petition number 21 of 2017. Of our interest is paragraph 23 and 24. In those paragraphs, Your Honor, the Supreme Court distinguished between 23 and 24. The Supreme Court distinguished between the responsibility of a court of law to apply the Constitution and to interpret the Constitution. There was a distinction. And the Supreme Court indicated that the responsibility of the interpretation of the Constitution vests with the High Court, while a magistrate court such as this one can apply the Constitution. And of course, the Supreme Court, Your Honor, was coming from Article 20, Your Honor, Clause 3, where it provides that in applying the provisions of the Bill of Rights, a court shall. the Constitution does not define the jurisdiction of the court. It merely provides the court shall. And for the court, for these purposes, therefore, means even this particular court established under this Constitution. And you are told, Your Honor, when applying the Bill of Rights, and again the law, the article provides the word applying, not interpreting. In applying the Bill of Rights, a court of law shall develop the law to the extent that it does not give effect to the rights or fundamental freedoms. So when you're applying this provision, Your Honor, even upon the basis upon which this prosecution was mounted, you are invited to apply the law and see whether there was compliance. If therefore there was no compliance with the law and it is so dictated that there must be a compliance, the question therefore would be, if the garbage in, or is it garbage out? If we have put in garbage, can we get any good end results at the fullness of time? Your Honor, you might want to look at that charge sheet that has been brought before you. You are told that our client ought to take plea for offenses, offensive conduct conducive to the breach of peace. And the conduct is as a consequence of his utterance.
All right, from the courts, we go to the United